So let's start the executive slides. So in this slide, we get to know about the crown and its functions. And here in this slide, we can see the rankings of the authorities of the crown. Like the number one is the constitutional monarch or the king or the queen. And number two is the head of state. Number three is the head of the Commonwealth. Number four is the head of the armed forces. And number five is the head of the Church of England. So these are the crown and their rankings. And their power levels start from the beginning. Number one has the highest power, and then the rest of the others. And in the next slide, the main functions of the crown: giving royal assent to legislation, opening the new parliament, appointing the prime minister, and granting honors and awards to the honorary persons. And the government is formed with five elements: the crown, prime minister, cabinet, MPs, civil servants. These are the five elements of the government. And now let's talk about the office of the prime minister. The office is a creation of constitutional conventions, and PM's power derive from prerogative powers. So what is prerogative power? The functions of the prime minister: appointing and dismissing all government ministers, controlling the cabinet. The PM is also minister for civil service. The PM is the head of the internal security services. And functions of the prime minister: the prime minister is the communication link between the queen and the government. The PM mobilizes the armed forces. The prime minister has special access to the media. There is no formal process to eliminate the permanent prime minister. And then the cabinet. By convention, all members of the cabinet are collectively responsible for the decisions taken. Example: Suella Braverman's paper article published without Number 10's approval. And prerogative powers, uh, also known as residual powers. So prerogative powers are a major constitutional source and relate to executive as well as legislative and judicial functions of the government. So these powers relate to executive level and to the legislative and the judicial functions as well. So remember these points. And prerogative can relate to legislature, for example, royal assent. Courts: the queen may pardon convicted offenders, but the queen cannot create a new system of laws. Then prerogative can relate to foreign affairs. Example: the restraining foreigners from entering the UK. In Immigration Act 1975, it was followed that way. War and armed forces. For example, in the Iraq invasion of 2003. Immunities and privileges, as tax is payable on income received by the sovereign. These are some of the prerogative powers. And prerogative can also relate to the emergencies, like armed forces taking immediate steps against terrorism within the UK. So these points are important for the prerogative powers. And example of prerogative powers, like declarations of war and peace, deployment of armed forces, entering treaties. But see Miller versus Secretary of State exiting European Union, 2017. We are going to talk about this in a later slide. Let's just go on for now. Recognition of the foreign states. Some other powers is power to take action in an emergency, power to stop prosecutions, granting of honors, granting mercy, issue and withdrawal of passports. And there is a case with the Home Secretary, ex parte Fire Brigade Union. The prerogative power is a residual power and will be replaced by statute, unless the statute specifically preserves the power. Section 11, Crown Proceedings Act of 1949. Party Fire Brigade Union. The executive cannot exercise the prerogative in a way which would derogate from the fulfillment of a statutory duty. So, no executive or none of the crown elements can exercise the prerogative powers in such a manner which derogates the fulfillment of the responsibility or duty of a authority, like the fire brigade. And prerogative and the courts. Are the courts allowed to question the way in which the executive use prerogative powers? In BBC versus Jones of the 1965, the court ruled that the Crown and the executive cannot create new prerogative powers at common law, so they are not allowed to create new laws. Prerogative and the courts. Le Carré versus Department of Trade of 1976, the role of the court was to determine that a particular prerogative power existed, not scrutinize the way in which it was can be seen for the arrow sign. So what happened in this case is that Laker Airways was a new airways that wanted to start their business across the United Kingdom and United States. So they got their approval from United States, but the United Kingdom's Secretary of the State dismissed their license, and whenever there is a airways license between Air United States and United Kingdom, it is called the Bermuda Treaty, and it is done under the Section 4 of the conventional law. But when the Secretary of the State dismissed this law, they went to the court and appealed against it. So the court said that the government could not use prerogative power to defeat statutory power. So the statutory power is a civilian right. It is their right to have starting a business of airways, and there is nothing the government can interfere in this. And that's how they got their license back and they started their business. And then in the next slide, there is another case, GCHQ 1984 landmark case. The House of the Lords, in the interest of accountability, some prerogative powers are subject to judicial scrutiny. So what happened in this case was that the employees of GCHQ stands for Government Communication Headquarters. So in 1980, the government led by Margaret Thatcher passed a rule that no employee of the GCHQ is allowed to join any trade unions. So, joining a trade union is the right of a citizen, but when the government interfered in this, then a new law came into existence and it stated that the interest of the accountability, some prerogative powers are subject to judicial scrutiny. So this means that the prerogative powers can also be sometimes subject to judicial review. They can be reviewed and analyzed if that decision is just or injustice. So GCHQ 1984 absolute powers non-reviewable by the courts. So absolute powers cannot be reviewed by the courts, like armed forces, foreign affairs, and emergency powers. These are the non-reviewable prerogative powers by the courts. These cannot be reviewed. And non-absolute powers, this can be reviewed by the courts. For example, power existing in the statute, and then mercy, like the Fire Brigades Union, and then new ground for review. Section 6 of HRA, which is the Human Rights Act, all public bodies must act in a way which is compatible with the ECHR or the Parliament excluded. Ministerial responsibility. Collective responsibility is taken by the cabinet and individual responsibility are carried on by the individual ministers. So it is a ministerial code. So here are some of the cases mentioned in Robin Cook Iraq 2003, clear shot Iraq 2003. We'll take a look into this as we go on into our next videos. Individual ministerial responsibility. Ministers must ensure that no conflict arises or could reasonably be perceived to arise between their public duties and their private interest, financial or otherwise. So there can be no conflict between that is right and what they do for their personal interest. So there can be no personal interest of the ministers. They should only think of the betterment of the nation, and their decisions should not bring up any conflict. So these are the videos that you have from the executive part of the public law.